Real estate purchase process in Costa Rica. Once the buyer has identified the property that they want, first thing that needs to be done is to sign some sort of documents. And this client have different options. One first option, it's what it's called a letter of intent. And a letter of intent is just that. It's a document that is addressed to the seller saying I intend to purchase your property pretty much under these conditions. But still no agreement between parties. Usually the letter of intent is given with what is called a non-disclosure agreement within the letter of intent, and just to make a first approach from the buyer to the seller. After this, and once more, the letter of intent is not needed, it's an option. What would be needed is to sign either an option to purchase agreement or a purchase and sale agreement, which is also called P&S. Option to purchase agreement. The option to purchase agreement is very well known in almost all countries, and we have it also here in Costa Rica. It's an agreement between buyer and seller in which the buyer agrees to buy and the seller agrees to sell X property under X amount and certain conditions or contingencies. And usually an earnest deposit is given. Usually is, especially between Costa Ricans, is a non-refundable deposit, which is also part of the final price. This option to purchase agreement is what it's very usual. Costa Ricans is what they like before going into the closing. At closing, we are going to sign what it's called, in Spanish, an escritura that needs to be done with a notary public. We can translate the word escritura into deed, D-E-E-D. Now, we also have the very well-known P&S, or Purchase and Sale Agreement. In some countries, and I'm not talking this moment in Costa Rica, the way of doing real estate is that a purchase and sale agreement is signed in which will identify, of course, buyer, seller, price, conditions, contingencies. And as you can see, it's pretty much the same as I have just said in regard to an option to purchase agreement. So what would be the difference between a P&S and an option agreement? That in the P&S, actually the buyer is buying and the seller is selling. However, they're going to close some days later if contingencies are removed or conditions are approved or are done. In an option to purchase, buyer is willing to buy and seller is willing to sell if contingencies are removed and if conditions are approved or are done. So it's a very slight difference between one and the other one. According to the Costa Rican law, the best thing is to sign an option to purchase agreement. Now I'm going to give you my personal experience since I've been working with foreigners for 17 or more years now. It's very clear, especially for Americans, especially for Canadians, to sign a P&S. Now they feel, I'm the owner. Obviously, we need to close, but I'm the owner. I have all the rights if all contingencies are removed if all conditions of the contracts are approved or are done. But in an option to purchase, it's just like, well, I'm willing and you're willing, but we haven't done it. So I have made a combination of this in all these years of experience with foreigners, and signing a P&S that is written down like an option to purchase in such a way that we combine both systems, the American or Canadian with the Costa Rican, in order to have a better understanding of the whole process. Now, this kind of documents will be done either or will be written down either by a real estate agent or a realtor, or could be done also by any notary. Does not need to be registered or so the only reason for it be done by an attorney or by a realtor is because of the wording or the way that you're going to write it down, but could be done even by the parties without a realtor or an attorney getting involved on this. Now, let me explain real quick what I call the Tico way of doing real estate in Costa Rica. When a Costa Rican would like to purchase a property from another Costa Rican, they will agree on price and they will agree when they're going to go and sign the escritura.
Verbally.
They could sign an option to purchase agreement, but they could just say, let's go to the notary, let's go to the attorney, and we'll sign the documents. And that will be the deed or the escritura, okay? In other words, we need, in order to close, to sign an escritura. We definitely need that. Some Costa Ricans that either does not have the money or need to go to a bank in order to get a loan or really want to study the property will sign an option to purchase agreement, but not all of them. That's why when I'm working with foreigners, I make this combination of option to purchase or P&S and then the escritura, and I put together the whole process. Okay, the whole process. And what would be that whole process? If an option to purchase or a P&S has been signed, part of what is important to have in those documents are, besides the contingencies, that it's case by case, depending on the property, we need to identify who will be making the due diligence, who would be an escrow holder, and who will be the notary. So this brings me to two different topics, and then I will continue with the process. Attorney versus notary public. In Costa Rica, in order to be a notary public, you need to be an attorney. First you become an attorney, then you become a notary public. And since 1998, in order to be a notary, you need to have at least 2 years of attorney experience. Means that you first need to be incorporated into the Bar Association, and from there on you need to be 2 years practicing law. And you also need to specialize in notary. Much better if you have a master's, but could be 1 or 2 years studying notary law, which is very different from other countries such as the United States or Canada, in which a notary is just to notarize signatures. Here, in order to record whatever at the public registry, you need to go, as we call here, before a notary. Mm-hmm. The notary needs to prepare the documentation and register this at the public registry. So actually, for a closing, for transferring property from A to B, what is needed is a notary, not an attorney. Obviously, this notary is an attorney, okay? The difference is that in some other countries, you will have two different law firms or two different attorneys dealing with the contracts. And once they have agreed on everything and all contingencies have been removed, then you go into the closing, and usually is done in a title company that will ensure that transfer. Here, we do not need title insurance because it's done in front of the notary. And the notary is the one that writes down the final document that is done in what it's called in Spanish protocolo. There is no translation for that, but I call it either deed book or protocol book, in which everything is written down there and it's signed by the parties. But only the notary could do this. So you can have attorneys involved in the transaction, but it's more to discuss about the first contracts, means the option to purchase, or to discuss about the due diligence, or to actually do the due diligence. But for the closing, the notary is needed. So you would have law firms with attorneys that will do all this, but a notary is needed for the closing. Now, there is a big question. Who will choose the notary? Let me explain. Let me go back to the process up to when we get into the notary. I also said that it's important to know who the escrow holder is going to be. Let me go back to the Tico way of doing real estate. Option to purchase, buyer will give the deposit to the seller because it's non-refundable anyway. Here it is. Part of the price, but here it is. And you can do whatever you want to do. But, in the United States, in Canada, in Europe, they're much more used to bring the money, the deposit, and then the rest of the money into someone that will, let me use the word, custody that money until the closing. And at closing, money will be released according to different instructions that are going to be given. Since 2005, 2006, there was created what it's called SUGEF, for the name in Spanish. And the translation will be the General Superintendents for Financial Entities. This SUGEF takes care and will control all the financial entities in Costa Rica, beginning with the banks, with all the banks, the major banks, and going down to financial institutions and either to companies or professionals that are registered with them in order to be able to take care of what is called third parties' monies. Means then in order to be able to be an escrow holder, you need to be authorized by SUGEF. There are several attorneys that they will custody money without being authorized by SUGEF. There are even realtors or real estate companies that will have money, third parties' monies, without being authorized by SUGEF. You need to be authorized by SUGEF in order to be able to receive third parties' monies. The reason? Well, because we need to protect buyer, seller, the government, and the world. And why am I saying the world? Because this is also to protect about terrorism, drugs, money laundering in general. So, when you write a contract, you need to identify an escrow holder, but you need to be sure that the escrow holder is authorized by SUGEF. And that is the second very important point that needs to be added in those contracts, besides obviously identify the property, the process, the amount, and the contingencies. Once the documents are signed, then we will begin a process that usually goes from no less than 30 days and no more than 90 days. What is very usual in Costa Rica is 45 to 60 days the most. For doing what? For doing what is called the due diligence, and for moving the monies to the escrow holder, for the escrow holder to investigate the person that is sending the money, to prepare the closing documentation, and to get to the closing date. So now we have in this process several things that need to be done. Let me first talk about the escrow holder once more. Monies could not be simply sent to the escrow holder, just here it goes. That's why I was saying the escrow holder needs to be identified, because once you sign, you immediately need to tell the escrow holder, you're going to be the escrow holder, what do you need? And the escrow holder will send to the buyer what is called a Know Your Customer form, and very well known as, when you see these letters, means Know Your Customer form, and will ask this person to fill up the form, or will help them, and to send not only the form, but also the documentation, the minimum documentation that is needed in order for them to send the money. And what is needed? Well, copy of the ID, which usually is the passport, valid passport. Fill up the form. Usually a utility bill. And why? Usually, especially the realtors and real estate agents and the parties are saying, why a utility bill? Because the utility bill will show an address which needs to match with what has been said in the form, in such a way that says, okay, this person actually exists and lives or have an office or whatever in this address. So that is why the utility bill, believe it or not, is so important. But now here it comes, the big discussion. From where the money is coming, and it's good money or not. We don't want laundering. And laundering is laundering taxes, laundering is terrorism, laundering is drugs. And there is about 300 different definitions of laundering money. So the escrow holder needs to understand that it's good money. So what is needed? The law does not say you need to bring A, B, and C. What it says is you need to prove that it's good money. So how do you prove that it's good money? Give me a copy of your tax return, for example. Well, if you're reporting all this, it means that you have the money. It's good money. Give me a copy of your bank statements with a bank letter saying, Mr. X has been a customer of our bank since 1994 with good standing and an average of 6 digits plus. Okay, this guy have money. And it's good money because the bank is saying. What we need, and from there on, you just tell me what could you send and it's going to be approved by the escrow holder or not. It's just we need to prove that it's good money. But it's not in order to bother the buyer. We don't want to. It's because we need to protect that buyer. We need to protect the seller. We need to protect the people that are involved in the transaction. We need to protect the government. We need to protect the world. And it's very clear, if there is laundering and could be proved, everybody's responsible. Means buyer, seller, attorneys, notaries, realtors, banks. Everybody will be involved in that case. That's why it's so important. But of course, realtors wants to sell, the attorney wants to get his money, the notary wants to get his fees. Everybody wants this to happen. And this is something that sometimes people doesn't like. But this is very important in the transaction. And of course, the escrow holder will send all the wire instructions, money that is going to be sent, and will be kept there until the closing. When we get into the closing, I'm going to explain again now what does the escrow holder what will be the role of the escrow holder. If documentation is fine, then the money could be sent. If something else is needed, the compliance executive of the escrow holder will say this is needed or this is needed. So if I am the president of an escrow company, as I do, I could not tell the compliance person, no, I don't want this or I want that. He is the compliance. He takes care of everything, and he will tell me this is needed, period. Otherwise the money is not going to come. Now, we also have the due diligence that needs to be done. The due diligence could be very simple due diligence, what I call the basic due diligence, or could be a little bit more complicated, what I just call it this way, the advanced due diligence. The due diligence could be done by an attorney, even though the notary that is going to participate in the closing will do also the basic. And what is it? Well, first of all, we need to check the property. And as we were saying, we have this very nice, huge, very well done public registry. So first thing we're going to do is to check the number of the property at the public registry. And this could be done by anyone. It's not only the notaries, it's not only the attorneys, realtors, or any person could just check that through internet. And we're going to bring up the basics of the property. What is it? Where it is located, who the neighbors are, the area or measurement of the property, who's the owner, and what is most important, if there is any lien and encumbrances, mortgages, what it's called annotations. That is the basic. Also, some other things should be checked, which is what we call the cadastral plan. All properties, in order to be transferred in Costa Rica, need to have what is called a cadastral plan or a plot map that is registered. That's why it's called cadastral. If there is none, there is zero, a surveyor is needed in order to make a plan, because otherwise it could not be transferred. So that is why it's so important. But we also need to see if it matches the plan with the property, and if not, why, what is exactly what is not matching. Might be the area, might be the name, might be different things. So if it is just a name, doesn't matter, because here at the public registry we will have the same number as we have in the plan. But if it is the area or something else, then the buyer might ask to have a new survey of the property in order to have a new cadastral plan. So that is the basic under the legal point of view. Now, usually I will go a little deeper and make a study in time, at least 10 years back, just to see what had happened in the property. But this does not need to be done by a notary. This is only done by an attorney if the buyer have asked for basic due diligence. Now also, in this basic due diligence done by an attorney, not by the notary, the attorney will ask for utility bills. If there is a house, obviously we would like to know that electricity and water is updated, and if there are some other services and it's part of the deal, well, they need to be paid up to the closing date. And taxes. What kind of taxes? 3 different taxes are very important to be checked. The most important one is what it's called the property and municipal taxes. In order to transfer, obviously, we would need to have the taxes updated. Well, that is checked at each city hall. And we can get a certificate that says up to date or has been paid up to the end of the year. And those are property taxes and municipal. Property tax in Costa Rica is 0.25%, a quarter of 1% of the value of the property. That is what we pay per year. Municipal taxes will vary depending on the services that are given in X area of where the property is located. Then, we also have a tax that is called a corporate tax that is important only if the buyer or the seller, it's a corporation. It's a Costa Rican corporation. And something that needs to be checked is that the corporate tax has been paid and it's updated. Otherwise, the transfer would not be registered at the public registry. And if what is being purchased is a house, we need to find out if that house needs to pay what is called the luxury tax. The luxury tax is a little bit more complicated tax because the luxury tax is based on the value of the property. But in order to get that value, we need to take into consideration the value of the building. What is the value of the building? And it's calculated in the Costa Rican currency, which is colon or colones. So I could not give you all the time the exact amount in other currency. But if we talk in US dollars, as an example today, as far as of today, August 2017, will be around $237,000, which the value of the house need to have in order to pay luxury tax. Once this has been determined, then we need to add the value of the land in order to pay the tax. So to pay the tax is not only the house, but the house and the land for the total amount to be paid. But to know if needs to be paid or not is only the value of the house without taking into consideration the land. If needs to be paid, it's also a small tax in comparison to several other countries because it goes from a quarter of 1% to up to 0.5 or half of 1%. And it's calculated depending on the value. Now, obviously, if the house needs to pay luxury tax, there's 2 things that might be needed. One, if it is already paying the luxury tax, the documentation needs to be reviewed, and we need to certify that the tax has been paid. And now the buyer, will know how much money needs to pay for this tax, which, by the way, is paid in the first month of each year. That's
a due tax, right?
Yes. Now, if there is no luxury tax that is being paid, but it's considered that it's a luxury house, then an engineer will be needed, or an appraiser will be needed that will go and check the house because it's a little bit complicated in order to calculate the value because you need to describe everything, not only the kind of house and the size, but if it is of concrete or wood, tiles, marble, several things that are included. So an engineer will do this and will determine if it is a luxury house or not. And based on that, then the luxury tax it's also calculated. Those are the most basic aspects that are needed in a due diligence. Of course, what I call an advanced one is if the purchaser it's buying a running business, a hotel, well, obviously, then accountants or engineers or some other professionals might be needed. And obviously, the price of the due diligence will change depending on which other professionals are involved. Some buyers will like to, in any case, even if there is a plan, would like to hire a surveyor just to resurvey the property and be sure that all boundaries are okay and everything is okay. And if there is a building, if there is a house, some buyers will like to hire an engineer in order to check the construction and the building and how it is. But this is more what I call an advanced due diligence. If people want it, fine. As a summary, what is definitely needed is to check the public registry, to make the studies of the plans, utility bills, taxes. Now, in this period that I was telling you that usually is given in the contract, which goes from 30 to 90 days, more or less, and once more, could be 15 or could be 120. It's totally open. I'm just telling you that in Costa Rica, usually 30, 60, 90, no more than that. In that time, also besides the due diligence, besides bringing all the documentation to the escrow agent, parties could get any other legal advice if it is needed. And also, it's a way of bringing the money into escrow before the closing. At the closing date, we should sign what it's called the escritura, the deed, in order to transfer property from A to B. This is done by the notary, and it's a very simple document, but could be complicated if the parties decide to. Means that basically it says that A sells to B the property that is described as follows with this price. No mortgages, no encumbrances, no this, no that, and that's it. This document needs to be done in Spanish, which is the legal language in Costa Rica. So it's done in Spanish. If the foreigner speaks another language and the notary knows this language, the notary, according to the law, has the ability to translate the document to the parties. Otherwise, if the notary does not speak the language of one or the two parties, then an official translator needs to be to be present in order to translate the document, which again is done in Spanish. Now, parties sometimes likes to write down in the document, in this escritura, something that is not needed but could be done, and is all the wording that was given in the option to purchase agreement or in the P&S as well. It's not needed. Why is not needed? Because all the contingencies have been removed, all the conditions are not there or have been complied, so it's only the transfer. But some parties will like that. Since that wording is not recorded at the public registry, needs to be said without taking note the registry. You write down all that the parties wants in the deed. As I've been pointing, this is done by a notary. However, if parties decide to have an attorney, then the attorneys could review those documents before signing without a problem. Now here comes the question. Who will choose the notary? Okay. The question is, how is the transaction? Means, let's say it's a cash transaction. Means the whole amount is going to be paid. It's not there is no financing in this process. If there is no financing, the buyer has the ability to choose the notary. Why? Because I'm paying cash. So I want to be sure that the document is going to be registered at the public registry. Okay? And that's why I choose the notary. If there is financing, now the question is who's financing and what kind of financing and what will be the collateral or the guarantee. So if a bank is involved, the bank will choose the notary, even though in the same document there's going to be a transfer and a mortgage. But then the bank will have the ability to choose the notary. If the seller is the one that is financing, then the seller has the ability to choose the notary. And of course, both parties could agree, if there is no financing or no banks involved, both parties could agree on the notary. Both parties could agree on paying half and half of the fees. I mean, among parties, they could agree on whatever. But what is usual, as I said, buyer will choose if it's a cash deal. Seller will choose if the seller is financing. Bank will choose if the bank is financing. As I was saying, then the escritura is a very simple document that is registered at the public registry. So it's signed in the deed book or in the protocol book. Then the notary will make what is called a testimonio or testimony in security paper with a security documentation. We'll pay the taxes, which I will explain that also. And we'll file this at the public registry physically. And it will take, if there is no mistakes and the public registry is not that full, it will take around 15 days. If there are mistakes, we'll come back. Mistakes are going to be corrected, file back. Will take around a month to be registered. If the public registry is going slow and there's not that much work, could be even registered in 1 week. I prefer to say 15 days, 22 days in order to be registered. Now, it's important that the notary files that at the public registry ASAP because of different reasons that I could explain later. Now, let's talk a little bit about the costs, what the costs are in a real estate transaction in Costa Rica. There is something that definitely needs to be paid. Notary fees, for sure. Transfer taxes, stamp taxes. Those are for sure in a transfer of a property. And all this are calculated based on the amount. So there are different calculations. One that is all the time the same is the transfer tax, which is 2.5% of the value of the transaction. All the time the same. The stamp taxes. Why do I call them stamp taxes? Actually, it's not the correct name. There are several small taxes that in the past used to be little stamps that were just placed in the deed. Okay? Now, of course, that is much more expensive than just paying the tax, and that's it. So the stamp this stamp has disappeared, but still have the same name, and there are very different ones. So we have a stamp that is called timbre. Timbre means stamp. So timbre fiscal, timbre agrario, timbre, and you continue naming different ones. Okay, and the tax that is paid is different from one to the other one. Just to give a little example. Timbre archivo, 20 colones, just to give an example. But there is another one that it's timbre fiscal, 650 colones, 650 colones. But there is another fiscal stamp that is more. And the agrarian one is more. And it varies a little bit. So the best thing of explaining this is there are stamp taxes which average is 1.1% of the value of the property. Very simple, because buyer, seller, realtors, or any other person involved in this transaction does not pay that. That is paid by the notary. So just let the notary do it. So it will be 2.5% in transfer taxes, 1.1% average in stamp taxes. And you also need to pay notary fees. That also will vary a little bit between 0.75% and 1.25%, depending on the value. So I would need to give anyone a big chart with all the values because it will vary all the time. So I just prefer to say, let's calculate 1.25%, 1.25%. That will be the notary fees.
1.25?
If it is a very complicated deed, according to the law, the notary could add a little bit more, but what is usual is that it's not added. Those are the costs that you definitely need to pay in a real estate transaction. Now, what are the costs? Well, you need to pay the escrow services if you are using escrow services. I said at the beginning, I like escrow services because it goes to someone that will custody the money. But the transaction could be cash in the table. Obviously now there is no cash transactions and no one wants to wire the money to the seller without signing. That's why the third party called the escrow, it's much better. And the escrow service, there is no law on how much to charge. So the market has given those values. And the market goes in an average of 1/4% of the value, or not of the value, 1/4%, 0.25% of the amount that is custody and distributed by the escrow holder, with a minimum of around $450. That is what the market is saying. Might change. Depends on the market and the transactions and who the escrow holders are. Okay? Now, when we get that is also one of the costs. The other cost is if buyer or if seller have paid an attorney for due diligence, which varies a lot from one law firm to the other one, from one attorney to the other one, what they want the attorney to do. So it totally varies what kind of property we're talking about. And in due diligence, you can add their accountants, engineers, surveyors, whatever the buyer wants. And that will be some extra costs that are not needed all the time, but would be good depending on the property. And there is no title insurance in Costa Rica. So no title insurance is needed, no need of paying this kind of expenses. Also, there is another cost involved that is a cost that goes usually, not all the time, but usually to the seller, which is the realtor's commissions or fees or legal or advice fees, or depends on what was the role of a real estate agent or a realtor. When just before the closing, then the escrow holder needs to send to the buyer what it's called what is the form in which the buyer will authorize the escrow holder to release the money according to the instructions, because the buyer usually is the one that pays stamp taxes, transfer taxes, notary fees, etc. So he needs to authorize the escrow holder to send this money to the notary, to make the payment, and to pay whatever he is authorizing. This is called the disbursement form for the buyer. But obviously, the seller will also have a disbursement form, because the money is going to go to the seller. So the seller needs to authorize to pay some other expenses, for example, realtors, or for example, stamp taxes or notary fees, if parties have agreed on paying that, both of the parties. So this forms needs to be sent to buyer and to seller in order to be signed and approved before closing. And then we go into the closing. At closing, then the notary will read the deed. Parties needs to sign according to the way they sign in the ID, means in the passport or the Costa Rican ID, if it is a Costa Rican. And after that, as I was saying, the parties will just leave. The escrow holder will begin to disperse the monies to whoever needs to get paid. And then the deed will go, the notary will file the deed into the public registry and will get registered. That document is usually given to the buyer. However, it could be thrown to the trash can because everything is registered and could be checked all the time at the public registry. If financing was involved, then the mortgage is also going to be registered at the public registry. Just to finish, it's important to say that what we are talking here is purchasing the property, means transferring from A to B, from a corporation to another corporation, from a person to a corporation, from a corporation to a person, but transferring the property. Some people will purchase not exactly the property, but will purchase the company that owns the land. And that is an option also. Now, the only big difference saving money is that the 1.1% of stamp taxes is not paid. But basically, the rest of the amounts are paid. So only 1.1% is what the buyer will be saving. And since it's pretty much easy to create a company, why taking all the liabilities of an already existing company if you can have a brand new one with 1-2 days totally clean and you just transfer, and you need to pay only that 1.1 extra, but it will be totally clean. But I needed to explain that that is also an option in order to purchase property in Costa Rica. So it's a very simple process, but everybody needs to know all these steps that I've been telling in order to understand why the timing, why the monies, what is needed, but also how you are very well protected in Costa Rica if it's well done and it's registered at the public registry.